this, this one I really, I'm sorry. This one I really liked, you guys. I don't know why this tickled me so much. Are patent and utility models the same? Why or why not cite each example? I just love how this is like I feel like I'm looking at a law school exam. Hi, I'm business and branding attorney Aiden Durham with 180 Law Co. in Colorado. Welcome back to All Up in Your Business. We're going to answer your questions and respond to your comments again today. First, if you're not already subscribed, go ahead and hit that subscribe button and the bell so you receive notifications anytime I post a new video and so you don't miss out on any of my hot legal tips and tricks. Got a lot of questions to go through today, so let's dive right in. Can I make a contribution anytime for my single member LLC or only when I'm forming it? You can make a contribution anytime as long as it's in alignment with the LLC's operating agreement. Most of the time it permits the member to make contributions at whatever time and amounts that the member decides. So as long as your operating agreement gives you that authorization or that permission, you can make additional contributions at any time. Can the trademark still get approved before using it, or will it get denied if you don't have any proof of usage at the time? I'm in the middle of designing a website and the trademark, I want to make sure it's available before putting in effort into designing it. The trademark registration won't be approved, it won't be registered until you're actually using the trademark, because a trademark isn't a trademark until it's a trademark. It's not a trademark until you are using it. So no, it won't be approved before you start using it, and it will be denied if you can't provide proof of that use. A best option, if you want to make sure you're protecting the name before you start using it, is to file on a 1B intent to use basis. Check out this video that I recently posted about the best time to file your trademark application. And of course, if you're looking for more help through this whole trademark process, check out Brandish, which is my online DIY course where I show you the exact process that I use with my clients, and we go through a lot of detail regarding the filing basis, intent to use versus current use, how to show proof of your use, that date of first use, and everything else that goes into it. I saw a nonprofit with the business name I want to use, but 2 different states. Can I still use the name for my business even though the nonprofit is using it? Can I trademark the name in my state even though the nonprofit is using the name in another state? For both of those, it depends. You can use a business name that somebody else is using. There's nothing that prevents you from doing that unless a court or a judge orders you or you agree not to in a contract. Of course, there's risk that this nonprofit may think it's trademark infringement or something like that, but you can always still do it. And registering the trademark in your state, if the nonprofit's using it in a different state, if their trademark isn't registered in your state, then it would be available for you to register in your state. But that doesn't necessarily mean that you have a whole lot of rights. If they were already using it, it depends. Short answer is, yeah, sure, you can, but the consequences or the results of it may not be great necessarily. How can NDAs affect you when working for 2 companies at the same time, and how would the employer find out if that's the case? An NDA really only affects you in the sense that you typically, it depends on the exact terms of the NDA, but typically you can't disclose any confidential information that you receive from your employer or the company that you're working with. You can't disclose it or use it for any reason besides performing your obligations for your first employer. So it would affect you by meaning you can't use any confidential information from one company. You can't tell the other company about it, and you can't use that info in performing your job for the other company. How would they find out about it? Great question. Maybe they wouldn't. Maybe they would get wind of it from another employee, or sometimes they just find out that you're working for a competing company and they have a suspicion that you're probably going to disclose trade secrets or confidential information, and so they'll try to take some action to prevent that from happening, even if they don't know that it's happening, but they suspect it's might. So, I mean, there's a lot of ways they can find out, but they might try to enforce it even if they don't know for sure, just on a suspicion. So speaking of NDAs, now is a great chance to tell you guys that I have partnered with my good friend and fellow trademark and business lawyer, Michelle Murphy, to offer her amazing contract templates from the CEO Legal Loft and her membership for the CEO Legal Loft. In these templates, you can find a template NDA. If you need an NDA or really any other kind of contracts for your business, check out the CEO Legal Loft at this link. And as a special bonus exclusively for my All Up in Your Business folks, if you sign up for a membership with the CEO Legal Loft, you will also get a promo code for 50% off of Brandish, my online DIY trademark course. So check that out using the links in the description if you want 50% off of Brandish. So talking about business deductions here, does that mean if I created my LLC in December, I can't deduct expenses I incurred in the previous months? And I've been working and buying supplies all year. Nope. You can deduct expenses that you incurred prior to when your LLC or your business entity was actually formed. Most startup expenses are deductible. There's rules and limits to what exactly can be deducted, but no, those expenses that you've incurred prior to starting the LLC can still be deductible like any other business expense can. This was very helpful. Thanks. Will the name on my EIN automatically change once I change the name of my LLC? No, changing the name of your LLC doesn't automatically change the name of your EIN. You do need to let the IRS know about that. You can do it either by writing them a letter, or you can check the box to indicate a name change on your next tax filings. Thank you so much for answering my questions. When it comes to trademarks, would you need to trademark the actual LLC, or can you trademark one of the DBAs? So this goes back to something that I cover pretty heavily in the very beginning of Brandish, my online trademark course. It depends on what the trademark is. What is the trademark that we're dealing with? Are you using the DBA as the trademark? Is that what the public is encountering when they are encountering your products or your services? Or are you using the LLC name as the trademark? It's not which one should I focus on, it's which one is the trademark that we're dealing with. So you would want to register whichever one or whichever ones you're using as a trademark. My LLC was in one state, then I closed and restarted it in another state within 60 days with the same business name. Is there a way to keep the history of that business so my business doesn't look like a new business? Just want to cut down on yearly fees, but didn't think about the history. If you close down an LLC in one state and form a new one in another state, it is, for all intents and purposes, a brand new business. The best way to move your business to another state whilst keeping that continuity and the history of the business is to do a conversion if it's authorized by both states. If that's not an option, then sometimes you can accomplish this by a merger or an acquisition of the two entities and keep that history of the first one still alive. But no, starting a new one and closing down the old one, you're starting brand new with a completely new, different business. Hello, Miss Aiden. If you are filing on a 1B intent to use trademark, do you put a future date in your application to when you will start using your trademark, or do you attach a specimen, or do you do a 1A? No, when you're filing on a 1B basis, there isn't a spot for date of first use. That question on the application doesn't show up if you select the 1B filing basis. If you put a future date, if you filed on a 1A basis, if you're not already using the trademark in commerce and you put a future date, the USPTO won't accept that. They'll give you an office action. You'll probably have to amend the filing basis to 1B and pay a couple extra filing fees potentially. And also, it's really, really important that that date of first use be accurate and correct as to when you actually started using the trademark in commerce. Check out this video to find out why that is so important. But no, the answer is no. On a 1B basis, you don't put the date of first use. You provide that later when you submit the statement of first use or the statement of use. If I apply for a trademark for a company name and see that someone else is using it, but in a completely different type of industry, will my application maybe have a chance of getting approved? Yeah, it maybe will have a chance of getting approved. If the industries are completely unrelated, then that certainly increases your chances of getting the trademark registered, but it also really depends on the mark itself. Let's say you are, your name is McDonald and you wanted to start something kind of related to food, or maybe not even, just distantly related to food. The people behind McDonald's will probably not like that. Same if your name's Disney. Disney does a lot of stuff, but let's say you wanted to start Disney, I don't know, consulting. I don't know if Disney already does consulting, but the fame and the strength of the existing mark, my point is that it also plays into it. Thanks for this video. I'm a little confused with first use. What if you haven't used it yet because you want to secure the trademark first? And then I included this person down at the end, at the bottom, who commented exactly. Just to share the question. How does it work if you haven't started using the trademark first? This is a perfect opportunity to file a 1B intent to use basis application. You get that process started before you started using the trademark in commerce. Of course, it won't be registered until you've started, but it gets that process going. So check this video if you want to learn more about when is the best time to file that trademark application. And of course, check out Brandish if you're looking for more info on how to go about filing an application on a 1B basis. I have a question. Good. I have decided to open an LLC and I will be funding with my own money. Do I need to decide how to get paid back for this money that I transferred to the new company? Yes and no. Typically, the money that we put into an LLC is considered a member contribution, and we're not entitled to a return of that contribution typically, except in the form of distributions. So the only way we get that contribution back is by making a profit in the business and then taking distributions of the profit. The other alternative to that is making it as a loan to the LLC instead, in which case it would be paid back as a loan rather than paid back kind of through those distributions. So if you're going to treat it as a loan, you need to decide that before you put the money into the business. If I'm getting sued for leaving this apartment abandoned back in 2013, they decided to sue me during the pandemic. Well, I mean, they couldn't evict people during the pandemic, so I guess they're going back to all their old cases and trying to get that money wherever they can. Sue me during the pandemic. Now I'm starting my business. Can they take the money out of my business bank account for the garnishment? Potentially. Depends on your state, depends on a lot of factors. This is typically what we refer to as a charge order, which means the debtor, the creditor, whoever you owe money to, they have the right to take from your member distributions from the LLC if they get a judgment against you. Whether or not they can do that, again, depends on a lot of stuff, but yeah, potentially they can't take money out of your business bank account, but they can take money from your distributions from the bank account. There is also, of course, I guess, the option for kind of reverse veil piercing, or instead of normal piercing the corporate veil, you're responsible for the business debts. In reverse veil piercing, it's the reverse. The business becomes responsible for your personal debts. That could be a possibility as well. Again, it all depends on a ton of different factors, though. Why does the U.S. government make things so complicated and in such ways which large businesses with top accountants can do so well, and the rest of us either have to pay up or suffer? Taxes should be fair and simple for all. I completely agree with you. I think it's kind of ridiculous that the government makes us do the math for them to tell them how much we owe them, and then if we get that wrong, we get penalized. Frankly, I think this might be one of those conspiracy theory things. I didn't realize I was a conspiracy theorist until just now, but it's all big tax lobbying the government to continue making taxes difficult so that we have to pay tax professionals to do it for us. But that's just my 2 cents. But anyway, yeah, I agree. Taxes should be fair and simple for all. I got an LLC for lawsuit protection. Is it safer to get an EIN than use your social security number for a business account? B of A allows the social security number but recommends getting an EIN. Do you have an opinion? I do have an opinion. I think it's better to get an EIN. The idea with the LLC, especially if you're doing this for lawsuit protection, the idea is separateness, and every little thing we can do to keep the business separate from you will help, and that includes getting an EIN rather than using your social security number. So even if it's not required, my opinion is that it's still a good idea. This one I really, I'm sorry. This one I really liked, you guys. I don't know why this tickled me so much. Are patent and utility models the same? Why or why not cite each example? I just love how this is like I feel like I'm looking at a law school exam. Unfortunately, I don't deal with patents. I know nothing about patents or utility models, so I have no idea if they are the same, why or why not, and I'm certainly not going to cite any examples for either because I'm not getting tested on this. Sorry, I can't answer your question. How are you? I'm doing well. How are you? How long is the trademark valid once submitting the application? Well, so the trademark isn't valid until it's actually registered, which is at least usually a year from when you've submitted the application. But once the trademark is registered, it can be valid indefinitely, as long as you continue using the trademark in commerce and you continue filing any required maintenance or renewal documents. If you keep all that up, then the trademark can last forever. Apple was sued by Apple Records, the Beatles, right? That is true. So this is on one of my trademark videos. But yeah, Apple Records, which was owned by or is owned by the Beatles. That's their like publishing or distributing company or something. Beatles had Apple Records, and then Apple Computers started. There was a lawsuit back in the 70s that they eventually settled. Then another issue came up in the 80s that they eventually settled. And then another one, I think in the 2000s, like around 2007 or something, another lawsuit that they eventually settled. And I guess now it looks like everyone's getting along and playing nicely, since as far as I know, you can get Beatles music on iTunes. So I'm assuming Apple and the Beatles are friends again. But yeah, the Beatles were concerned that Apple Computers were infringing on their trademark. And, you know, over the last 30 years, there's been a handful of back and forth about that. By the way, speaking of the Beatles, have any of you guys watched that Beatles documentary on Disney Channel? I just finished it. Pretty interesting if you're a Beatles fan. If you're not, it's going to be boring as crap, but pretty interesting. If you like the Beatles, highly recommend it. All right, great round of comments and questions this time, you guys. Keep up the good work. If you found any of this valuable or helpful, hit that thumbs up like button. Share this video with all of your friends to spread the good word of All Up in Your Business. Be sure to check some of my old videos for additional info, and check out Brandish if you're looking for more help with DIYing your trademark application and you want to learn the exact process that I use with my clients and the precise things that you can do today that will have you ready to hit that submit button on your trademark application in only 7 days. Thanks so much for watching. I'm Aiden Durham, and I will see you next time.